Good morning and welcome to this webinar. We're just waiting to onboard everyone and then we'll start formally. Right. Hello and welcome to those joining the CECA legal update on the Employment Rights Bill Government Roadmap that our HR partners Weightmans have kindly offered to deliver. I'm David Allen. I'm the Executive Director for CECA Southern Limited. But before I hand over to Seema Chapanary and Ingrid McGee from Weightmans, who will deliver the presentation, I'll update you on a few of the house rules and then provide you a bit more detail about CECA and what we do. We will be recording this hour-long session and invite questions to be dropped into the chat. Where possible, these will be picked up during the Q&A and at the end of the presentation, or questions can be asked directly in that Q&A by using the raise your hand function. Please can you put your microphones on mute so that we don't have any background noise, but also note that the recording of this meeting, which is happening now, will actually be turned off for the Q&A session. So hopefully that will help everyone come up with any questions they have to ask. If you may need a bit more information than we can actually provide today, then there could be some follow-up contact with yourselves about that. Just to give you an update on CECA, CECA Southern is just part of the Civil Engineering Contractors Association. We're a not-for-profit trade body that represents and promotes the interests of those organisations that collectively deliver about 80% of the civil engineering infrastructure delivered on the mainland UK. If we turn the slide, please, Ingrid. We are made up of 6 English regions, 2 devolved nations, and have a policy and external affairs office in Westminster. We engage on behalf of our CECA members with government and public bodies at a national and regional level, and similarly with key clients in both the public and private sectors. We're also on the Construction Leadership Council supporting the infrastructure voice. CECA look to create a window on the wider industry for our members to ensure that their voice is heard, and by doing so, increase the awareness of that wider industry around the needs of our sector. We are a members organisation and we're guided by our members, and we deliver against our 5 core CECA pillars that consider clients, policy and workload, health, safety and wellbeing, skills and training, careers and recruitment, sustainability, carbon and social value. We engage with industry partners to widen the service that we can provide to our members, and have been working with Weightmans this year to increase our offer around HR matters. With this webinar today providing an update on the Employment Rights Bill Government Roadmap being just one example, and that will hopefully reinforce your own awareness. I will now hand over to Ingrid and Seema from Weightmans to deliver the rest of this webinar. Thank you.
Thank you, David, and welcome everybody to the presentation today. I'm Seema Chapanary. I'm the commercial lead here at Weightmans HRLI. My colleague Ingrid McGee will be doing the update on the Employment Rights Bill, but Ingrid, if we can just skip to the next slide. First of all, I just wanted to explain to you as members of CECA about the support that you have in place now through our partnership with HRLI and CECA. So I'll be taking you through a little bit of the membership benefits that you can benefit with our offering. And we'll also then be talking to you about the Employment Rights Bill and what we currently know, and about the roadmap and timescales of that. So if we can just go to the next slide, Ingrid, and yeah, we'll skip to the next one as well. Thank you. So first of all, I just wanted to explain to you who Weightmans are. So we are actually a full service national law firm. We have 10 offices across the UK. So we're very well spread and able to support clients wherever they may be. And we'd obviously share these slides with you following the webinar, so I won't go into all the details on here, but these are some of our fantastic accolades that we have. The one in particular that I really wanted to draw your attention to was the Top Employer Award. So we have actually won this as an employer ourselves for the 18th year in a row, having been in the top 5 in the last couple of years. This is something that I really wanted to particularly draw your attention to, because I think it demonstrates that we here at Weightmans practice what we preach in terms of how we support you as employers and how we guide you to sort of, you know, ensure that you are being employers of choice, etc. So it's not just about being legally compliant, but it's being sort of at the top of your game in terms of that respect. If we can just go to the next slide, please, Ingrid. So we, as David said, we have been partnering with CECA for a while now. We actually started our partnership with Lorraine and CECA Midlands region, and that was in July 24. Very quickly, by January this year, we'd actually decided to, and been lucky enough to partner with CECA nationally. And this is the beginning of a series of Nations and Regions roadshows that we're doing with CECA Midlands as your official employment partners. The CECA partnership with HRLI at Weightmans basically gives you a number of benefits as an organisation, as a member of CECA. You get access to a monthly employment newsletter. Hopefully you start to see that come through on a monthly basis with updates on sort of topics that are relevant to you as employers. We also have an exclusive discounted sort of preferential rate for CECA members if you need some additional support, and I'll talk to you a little bit more about that in the moment. And then obviously member events such as this, and we're also open to sort of suggestion on other member events that you might like for us to host for you. One of the things I didn't mention about when I talked about Weightmans is that we are a large law firm, and the beauty of that is that we can actually specialise in particular areas. We do have a deep specialism in the built environment, and therefore we're able to give you specific bespoke advice for the type of organisation that you are. We are actually running an event in January around the CIJC terms and conditions, so that just goes to talk to how we do specialise in this area. And then I will talk to you a little bit about the wider offerings we have at Weightmans that you can benefit from as well. So next slide, please, Ingrid. So these are just some of the areas where we really sort of stand out in the marketplace and how we can support you. One of the kind of key USPs that I'd like to sort of hone in on really is our cost certainty. So obviously HRLI, our service, is offered from a law firm, and traditionally that sort of does make individuals, organisations feel a bit uncomfortable cost-wise with sort of, you know, charging structures, etc. But the beauty of HRLI is we have set it up as a retainer model, and what that means is that we can give you as much cost certainty around how the service supports you, and therefore there's full transparency around that, and it's much more cost manageable from that perspective. The other thing that's a real USP about how we support our clients, we do offer HR level advice as well as legal advice, and however all of our advisors are qualified legal advisors, and therefore we can support from the really informal stage end to end all the way through to you know, tribunal support and that type of thing. So really there's nowhere for anything to fall between the cracks, and we can support consistently throughout the life cycle of any situation that you may come across. Next slide, please, Ingrid. There we go. So obviously we'll be talking to you about the Employment Rights Bill later on. Oh, Ingrid, we've lost the slides.
Oh,
there we go. Thank
go.
you. So she will be talking to you about the actual sort of what's happening at the moment with regards to the Employment Rights Bill, but these are just some of the examples of the types of situations that we can help you as CECA members with. So sort of setting up policies and procedures, etc., for effective recruitment. Very, very important, obviously, as employers, to make sure that you're not only getting the right talent in the door, you're retaining them, but you're also sort of fit for sort of the growth of the organisation, etc. Handling disciplinaries and grievances. Obviously, if that's not your area of expertise and you don't have that experience, it can be a very daunting task and sort of can feel a bit like a minefield, and we can help you and guide you through that. Handling bullying and harassment and other employee conflict, again, can be operationally burdensome, and can really sort of be, needs to be handled with care. Equality, diversity and avoiding discrimination claims. These are also sorts of things that we can help our clients through, which can be particularly tricky. There was obviously some legislation that came out last year around prevention of sexual harassment, and we can help with those sorts of things with training and policies and that type of thing. Managing sickness, absence and disability. The managing sickness, absence piece can be obviously very costly for employers if they're not dealing with that, and sort of helping to encourage employees back into the workplace. And disability around reasonable adjustments and that type of thing. Performance issues, redundancies and restructuring. Again, we help our clients with a lot of these types of things. Also GDPR, subject access requests. All of these are just examples of things that we help our clients with at the moment. Obviously terminations and dismissing an employee fairly is incredibly important, and lots of other employment related matters. So hopefully that just gives you a bit of a flavour of the types of support that we can give. Ingrid, if we can move to the next slide, please. Okay, so just a very quick overview of our two packages that we have. So we have a gold and a platinum package. The gold package is really aimed at the SME market space. So it's essentially an hours package. You buy 5, 10, 15 hours of advice. As you can see, you still get a lot of the value add that you would with the platinum package. The platinum package is designed for employers with staff of about 100 or more. And I'll sort of, explain to you the cost of that will be quoted for, whereas the gold package, we have the costs laid out for you. Members would get access to a dedicated team of advisors, a named team sheet of advisors that would get to know your organisation. You get access to a document library with template policies, documents, letters, that type of thing that you can access as and when you need to. Regular invites to member events, etc., and ability to sort of have dedicated tribunal support as and when you need it, really. With the platinum service, we also include a standard health check of your core policies and contracts of employment at the beginning. So if we can go to the next slide, please. I did mention earlier about bolt-ons. So what these are is essentially all of the services that sit around the main advice package. So it might be that you need a bit of support in some other area that we can help with. The brilliant thing is that we can actually package these additional services for you, again, in a very cost sensitive way. So we can give you an upfront costing around this type of support. This is just an example of a couple of the bolt-on services that we often have alongside HRLI, but there are many, many more that we can offer, things like cyber security, commercial contracts, all of that type of thing, because we are a full service law firm, so we can lean into those other areas. Next slide, please, Ingrid. And then this is really just the member offer that's available to you as CECA members. As you can see, it's a very, very preferential rate, and you're getting this service from a really kind of renowned law firm, and we can support your members with some of these really tricky situations that may come up at these very beneficial preferential rates. I think the message really that we wanted you to come away with is Ingrid's going to be talking to you about these things that are coming over her horizon, and what we wanted to make sure is that you feel supported as CECA members and understand that there is support there available to you in a very cost-effective way should you need to tackle some of these issues. So at that point, I'm just going to hand over to Ingrid to cover off the Employment Rights Bill. Thanks, Ingrid.
Thanks, Seema. Thanks, and good morning, everyone. Just whilst I've got that slide up, I just thought I would say that's just a kind of indicative or recommendation. That's not to say that someone or a business that has up to 25 employees might not benefit from more hours. I think it really depends on how you're set up internally. You might need more support and might need more hours in that package. So again, I would just say, there is a flexibility there to move within those parameters to best suit your needs. So I just thought I would capture that as well. So I am here this morning to discuss the Employment Rights Bill. This has been ongoing for quite some time now. This may be my 20th or 30th update that has seen very many iterations over the last few months, because we've had consultations, we've had the movement through Parliament, which is still happening at the moment. We're waiting for royal assent. So again, what it's really focusing on this morning is a general understanding of what's on the horizon in terms of what's happening next April, what's happening next October, and what's likely to come into force in 2027. And you might think this is quite far ahead. Why are we looking at it now? All good businesses plan in advance to make sure that they're all set up and are ready to go whenever these changes actually take effect and should be implemented. So some of the areas that I'm going to cover off will relate to unfair dismissal, flexible working, 0 hours, fire and rehire. Big one for me in that regard, and I don't know how everyone else will feel about that. I'm just conscious I can't see everyone. So if someone does have a question whilst we're taking it at the end, if you want to jump in, I won't be able to see a hand up or anything, so feel free to jump in, and hopefully I'll have the answer, and if not, I can follow up. I'm also going to cover off family leave as well, because there are some changes that are coming into effect there. Collective redundancies, statutory sick pay, fair work agency, family friendly rights and NDAs. We've got a bit of blurb there on both of those slides just to give you a bit of an intake as to what they all include, but I'll go into a bit more detail around all of that, conscious that we have limited time this morning. So I want to get through as much as possible and just get out the main points that I think you as businesses should be aware of. So the first one is in respect of unfair dismissal. Now, this was a big manifesto claim and proposition that the Labour government put out there. And obviously with the Labour government in power at the moment, you will see, and we have seen, more focus on employment aspects and employee rights. And this is probably one of the biggest ones that have really hit the headlines, and for very good reason, in my view. At the moment, we currently operate a 2-year unfair dismissal right, i.e. if you don't have unfair dismissal rights until you have acquired a continuous period of 2 years service with a business. So essentially, I always say to businesses and to our clients, you do effectively have 2 years to decide whether or not you think someone is suitable for the role or not. My view is that you shouldn't be waiting up until the 2 years. You should kind of know that within the first, say, 3 to 9 months of someone starting with you. You should have the right mechanisms in place to kind of sense check that. And you should have the right managers in place to make sure that's being done consistently, fairly, and accurately as well. So what is being proposed here is that they're going to get rid of that, and that there is an ability to raise an unfair dismissal claim from day one, essentially. And it's a day one right. I think it will have an impact on businesses. I think it'll have an impact on the Employment Tribunal Service as well, which are seeing some cases not listed until 2027 or even 2028 in some areas. So I think this will increase litigation, and there'll be a lot of satellite litigation. But just to give you a flavour of what this means, what it is effectively they're going to allow for what we would suggest probably around a 9-month initial period of employment, a probationary period. There's going to be a lighter touch process and a reasonableness kind of test that will be adopted for any dismissals that take effect within that period. And again, there might be less compensation that could be awarded for those who are dismissed within that initial period. What I think businesses need to do is to, one, keep on top of this, because it's not yet to come into force until 2027. So I think there might still be a little bit of movement around this. But my view is any good business should already have good mechanisms and processes in place. Now, again, I can't see you all, but when I normally ask the question, how good is your appraisal system? How good are your managements? How your managers, how good is EI within those managers, emotional intelligence. And why that is all important is because one, common problems and common issues that we see with employment tribunal claims is when there isn't a consistent appraisal process or performance management process. So that is something that you would probably encounter within the first year of someone's life cycle when they start work with you. So what checkpoints do you currently have built in place and to monitor conduct, to monitor performance, even to monitor absence in some respects as well? So if you don't have that in place now, that's something you should have in place anyway, regardless of the Employment Rights Bill coming into effect in this particular aspect in 2027. And what I've said to other clients is that you might want to look at your contract to understand what your probationary period clause says. Do you have one? You should. What process will be followed in the probationary period? How will it be extended if required? In what circumstances will it be extended? And again, what we might see is a two-tier approach to dismissals within that first 9 months or even a year. So again, you need to be really clear on what that is across the board. Problems always arise when employees are caught off guard during an appraisal process, whereby it's maybe the first time they've heard that there's an issue with their performance or their conduct or how they spoke to someone 3 or 4 months ago. So again, from a management perspective and a leadership and culture perspective, you really want to make sure you're nailing that process. If I've got an issue or there's something that needs to be discussed with a member of my team, I will have that discussion as soon as possible, because there's no point sitting on it. So again, you want to make sure your managers are doing that and also have the skill set, capabilities and comfort and confidence to have those difficult conversations. They're not easy. So some managers progress through the ranks on the basis that they've been there for a certain period of time. But what training are you delivering to those managers to have these conversations to make sure everything is run smoothly in that respect as well? So again, we'll keep you updated on all this, but I think that has been quite a big headline grabbing change that is likely to come. I don't see that moving. House of Lords tried to suggest that it should be brought to either 6 months or a year. I can't remember the detail now, but again, that was rejected when it came back to the House of Commons. So it's likely to be something that is pushed through, but there might be some nuances around the regulations about how that actually works in practice. For those of you who not necessarily as old as I am or have been around within the employment space, there was what we used to call the dispute resolution procedures, where there was a very prescriptive process you had to go through to dismiss someone. I'm not quite saying we'd go back to that, but I think that will be somewhere that we'd meet in the middle in that respect. In terms of flexible working, what is being suggested here is that the right to work flexibly will be a default right. That's a slight shift. And what I mean by that is at the moment, the right to work flexibly, it's not the right to work flexibly, it's the right to request, to make an application to work flexibly. So the shift in this is that there's obviously more focus on a more flexible workforce. And there are sometimes, I think, within your sector, there can be a hesitancy or a lack of understanding of how flexible working arrangements may work within your sector. Now, we have seen more movement to accommodate flexible working requests, but it's sometimes not something that is readily accepted. And I know that there are challenges around that. But when this comes in, I think the main thing to understand around that is that whilst we've been able to reject applications for flexible working because there's been some sort of procedural error or the process hasn't been followed to an extent, businesses will now need to ensure that any refusal must be reasonable. So we're attaching that kind of reasonableness assessment as to why you're not granting a flexible working application. And again, the reasons must be in writing. There have been some changes to this over the last 12 months in terms of there's less of an onus on the employee now to come up with how it will impact the business, how it will impact the department, and how can we go around alleviating those barriers or those issues. The onus has definitely shifted more on the business to understand why can't you grant it? What is it that you're saying you will face? So advice and recommendations I've currently been given to business is that it would be helpful if you have the time and resources, but even if not, I still think it's an exercise worth carrying out to understand how your department and how particular job roles currently work and where your flex is in terms of, could you have part-time working? Could you have compressed hours? Could you have job shares? Could you change where they work? And again, not that you would have this as a black and white, this is how we would consider it for all applications, but it would give you a parameter as to, and make you think about it now, where the challenges might be and why you might want to consider it, and or why you might want to reject it. But when this comes in, you will need to be clear on the fact that you've carried out that assessment at the time. I wouldn't say that you could just rely on, no, we just don't do that. We've done an assessment a year or 6 months ago. It's not going to work. You have to take each application at face value at the relevant time. And I think what we will see is that when you normally agree to a flexible working request, whenever that change of hours, change of location is implemented, that is a permanent change to that employee's contract of employment. So it's not as if you can say, we'll just see how this goes and we'll change it back, unless you have agreed a trial period. Now, you have to make it very clear at the outcome of any flexible working request that any agreement is for a temporary or a trial period, what the parameters would be about when this could be permanent, and on what basis and what circumstances will we say, do you know what, this isn't working? And what period of time do you give that? So normally I would say around 3 to 6 months, you might want a trial period. If it's not working, what you have to make clear in any letter at the outcome of any flexible working request is to say, do you know what, this isn't working, and if it's not working, you will automatically revert back to your original working pattern, your hours, your location, whatever it might be. But at least you as a business can demonstrate you gave it a go, you were reasonable, you understood what the challenges were, you tried to work through it over the last 3 to 6 months, which we would argue is a reasonable period. It's not worked out, we're going back to status quo pre flexible working application. So I think trial periods will be more common. I think they're a really good tool, but you need to be clear that your letter and expressly setting out what's been agreed at the outcome of a flexible working application process, what's been agreed, and how it can be impacted going forward. I think that's where businesses get it wrong, because I think sometimes they think we'll just go on a trial period and then they forget about it, and it's been like a year, and then they say, no, it's not working. And when they come to me as an advisor, I was like, you kind of left it too late. It's going to be a really big challenge. I think this is now a change to their contract. I think, try and unravel that is a legal risk. So you then have to outweigh whether or not you want to take that risk on or not. If not, then you're stuck with that arrangement, or what are the other options? So again, really important to get the right advice in these circumstances. In terms of 0 hour and low hours workers, this is probably a reaction to, or the sports, I think it's the sports direct model, I can't remember now. But anyway, it's Mr. Ashley. We all know who Mr. Ashley is. So I think the issue with this is that there was a consideration that 0 hours or low hours contracts were, the individuals engaged on these contracts were exploited effectively, and they were said to have 0 hours, no guarantee of hours, but in reality, it was very clear that these individuals had worked a set number of hours for a set period of time, and therefore they, these were morphing into something beyond what was initially a 0 hours contract or arrangement. So the government have built in legislation to come in 2027 around this. And what this means is that if there are regularly worked hours, or there is a reference period which will be 12 weeks, if you can see that an individual is working a set number of hours, set number of days, and they have done over a 12-week period, businesses will need to offer a minimum amount of guaranteed hours to that employee or to that worker. That makes sense. I get that, but I think there's a lack of understanding that those that are engaged in 0 or low hours work might not want to be held to a certain number of hours. And then what's happening here is it's putting the onus on a business every 12 weeks to check in. Do you want to change? Do you want to have this contract? Do you want these hours guaranteed? So it seems quite onerous, and I think there will be some changes around how this may be implemented. Will it be something that employees or workers opt into and say, yeah, I would like to check in on this on 12 hours? Or would it be that a business says, we'll check in with you in your first 12 weeks, and after that, you can confirm whether or not you want to be offered these guaranteed hours, and they might sign an opt-out or something along those lines. But again, I think it's an interesting area, because I think it will work for some businesses where they might want hours guaranteed, but my view is if they wanted that guaranteed in the first place, or the workers did, we would have been there anyway. We would have offered that. So I think the key issue around that is making sure that you're clear with engagement, recruitment, what the hours are, why it wouldn't be guaranteed, what their parameters are, and again, having conversations like, if this was to be more regular, is that something you would want to have change? And then you would put it out in writing, or a change of contract or a variation letter in that respect. But again, I'm not overly concerned around this one yet, given the timescales, but I think it's quite onerous on businesses and employers. So this I mentioned in the introduction, it's probably quite a big one for me in terms of fire and rehire. I would say over the last, I've been practicing and in law for over 20 years, and specialised in employment for probably 18, 19 of them. And I would say over the last 7 to 10 years, kind of reorganisations, restructures, redundancies, changing in T's and C's are kind of in an area of focus and project management with clients I deal with. So fire and rehire, I think, can be, when utilised correctly, a really good tool for businesses. And what I mean by that is fire and rehire is usually used by businesses when they go through a consultation process. So say, for example, you want to either change hours by, could be a half an hour, an hour, or you want to change working patterns, but it's something that you need to do across the board, wholesale changes. Normally you would consult with employees around all of this, try and get their agreement, make sure they understand this, say when it's going to take place, why, have those meetings, have really good employee relations and process and conversations with employees before carrying this out. And if at that point you feel like you're not getting the agreement that you need, then businesses may look to dismiss employees on their current T's and C's, terms and conditions, and then re-engage them, i.e. hire them back again on a brand new contract, which pretty much is exactly the same as what they were initially applied, but then tweaks the changes they were trying to get agreement and implement through agreement with employees. It's been a really effective tool. I've used a number of times. It's usually a last resort, but because of the P&O disaster, PR disaster, well, it comes about 2 or 3 years ago now, I think this has been a reaction to how badly that was handled and also perceived by the general public, by trade unions, by government. So what they are now saying is that you won't be allowed to fire and rehire unless you can demonstrate that there is imminent financial impact or constraints or risk to the business. There were some amendments, as we said there in July, that the dismissal will be automatically unfair if there's a restricted variation, but restricted variations refer to any variations pay or in hours or working practices, and that is ultimately what we would normally use a fire and rehire model or process to kind of affect. So what I've said to clients now is, because this is likely to come in or around October next year, is have a look at your working practices, have a look at your contracts of employment, have a look at your policies. What's working for you now, what's not working, because try and get those changes agreed and implemented now. Because if you're looking to do this post-October next year, these would be, on the face of this, an automatically unfair dismissal. You don't want to get into that territory. You don't want to try and have to justify, because the other thing around this is that fire and rehire is a really useful last resort tool to safeguard a business, to kind of understand your forecasting, and this is the model we need for year 2 or year 3, but you want to get it in place now. under this new regime, you won't be allowed to do that, because then you wouldn't be able to say that you are at imminent financial risk right now. You know, I think it's quite severe that businesses would almost need to justify that maybe they have to shut the doors right now. So again, that's not where this is usually utilised. So I think I have issue with this, because I obviously have advised on this over the years, and I think it can be, I keep saying it, a last resort tool that is really helpful for businesses when they've really tried to consult and really try to engage with employees on any proposed changes that are necessary for the business to be in a particular structure, to work in a particular way, to adapt to market forces. So I think this change has a huge impact actually on the business's ability to flexibly manage a business in the right kind of way when agreements not been sought or achieved through any form of consultation. The other thing around this is that the protective award, if we're getting this wrong in terms of when there has been an unfair dismissal and we should have collectively consulted, then the protective award for each employee impacted currently sits at a 90-day gross pay. This is being suggested that it will be increased to 180 days gross pay. And the reason they've done that, in my view, is to kind of made employers go, do you know what? Like P&O did, they paid individuals financially what they would have achieved and what they would have been awarded if they'd gone to an employment tribunal to raise claims about this. So they just made it a bit more expensive. So that's not an option that businesses go, do you know what, if we just pay the 180 days and we pay whatever else and still dismiss and re-engage, we'll take the hit. And I think when you're dealing with huge numbers of employees with dismissal and re-engagement or redundancies, that's a huge price ticket. So again, that's why they've done that. So yeah, I think this is, it's still under consultation at the moment, but it's looking to be coming out next October. I think there will be some tweaking again. I'll keep you updated on all of that, and the firm will. But again, it's just to understand. I think this will have huge ramifications for a number of businesses, because it limits their ability to move a business forward in a way that we've been able to do for a number of years. So collective redundancy is another one, kind of linked to what we just said. So collective redundancy, so that is when you have to follow a prescriptive process when you're making redundancies or dismissals, in fact, or when there are 20 or more employees going to be dismissed at any one site within a 90-day period. So if you're going to dismiss 20 or more, then within a 90-day period, you have to go through a minimum consultation period of around 30 days. And when it's over 100 employees within a 90-day period, it's 45 days as a minimum. So what we've always been able to do whenever we are carrying out collective redundancies, when you've got businesses, and some of you may have this, where you're spread out nationally, you don't need to take the 20 or the 100 that are being made redundant in the 90 days across the company. It's what's the site that this is being impacted, and if it's not 20 there, it's only 5, then you don't need to go through collective redundancy, which means engaging with employee reps, maybe going through a voting and a balloting process, being very prescriptive about how you communicate, how you consult. But this change is being suggested that this well-established principle since the Woolworth case about it being on a site-by-site basis is going to change. It's going to be widened up to a number of people affected across an organisation. So if you do have a national organisation, it means that if 20 or more within the business nationally, it could trigger collective consultation. Now, again, not great for businesses who are spread across the UK, because you need to make sure that you're all speaking to each other, you all know what's going on in other sites, because if it adds up to 20, you trigger collective consultation. But there has been some movement, so it will be 20 or more in each site, or there'll be now a minimum threshold across all organisations, or sorry, all sites. So that's helpful, because at least there is a demonstration of some understanding that what was initially proposed was a bit crazy, because we were worried that businesses may look to then set up separate entities to then cover up different locations so that they wouldn't have to go through collective consultation and trigger the 20 or more employees at each site. So I suppose the next thing for us to understand is, what is that minimum threshold going to look like? Is it going to be a percentage of the workforce nationally? Is it going to be a particular number? So again, we don't know that yet. We don't have that detail, but it is a move in the right direction in understanding that businesses who operate on a wider scale or on multiple locations and sites need that comfort. What I would say, though, is if you don't have it in place already, have systems in place. How do you know what is going on in other sites and locations, so that if the minimum threshold is met, you're on it, or you know you're on the cusp of it? And again, it's within a 90-day period. So again, you need to have systems in place and the reporting mechanisms to understand how that's going to work and how that's going to impact your business, especially if you are a business that goes through a lot of change management, that might look to dismiss and re-engage or make redundancies across the board. So again, that's not for next year, likely to come into force into 2027, but the government anticipates consulting on its proposals again, kind of now and early 2026. So yes, if any of you as well within the business consider that this is anything that I'm mentioning is of huge concern, please think about how you can engage with the consultation process as well and feedback. We can collect views as well and then push that forward, because we're on a number of forums where we're providing feedback throughout the consultation. So if there's anything that you think is worthy of note or worthy of sharing or putting forward, again, please do let me know. Statutory sick pay, this is quite standard in that when this comes into effect, which I think is next April. So you should all be aware of this. If not, make sure your HR or payroll are aware of this. There will be no 3-day wait. So normally the first 3 days of anyone's absence, you don't get SSP. You get it on the 4th day onwards. I think it's up to a period of 28 weeks thereafter. So for this, there's now not going to be a 3-day wait, and also there's not going to be any lower earnings limits. So, which I can't remember what that is. Actually, I'm just seeing if my notes have it. But it means that up to 1.3 million employees who currently earn lower than the lower earnings limit will be entitled to SSP, and will be entitled to it from day one. So a lot of my clients, and again, I don't know if you carried this out, but are doing a desktop exercise right now to understand what is the cost implication of that. Look at your trends, look at understanding what percentage of your employees are usually sick. Are they sick for more than 3 days? And also, are any of those under the lower earnings limit that you've not paid? There's 3 key areas that I would be looking to understand right now, because that will add to a financial cost for the business come April next year. So again, that's something to be mindful of. The Fair Worker Agency, this is an interesting area in that it's an enforcement, it's going to be a new government body that's going to bring together a number of delegated functions, and it will, as an agency, enforce national minimum wage, SSP, holiday pay, and other things like maybe COP3 agreements, settlement agreements, payments that should have been made from employers to employees. And again, the aim of this agency is to support workers and good employers and punish bad ones. We've all seen the naughty list that can sometimes the name and shame for those who aren't paying national minimum wage. But again, this could broaden the scope at which that could happen as well. So I'm saying to clients, how confident are you that you are paying national minimum wage, SSP correctly, holiday pay? Holiday pay is moving feet all the time and changes constantly. It's changed, I think, 3 or 4 times in the last 10 years. So again, make sure you have either systems or clear understanding and policy about how you calculate holiday pay. Are they normal working hours employed? Are they irregular? Are they no normal working hours? How do you deal with that? And again, in terms of COP3 settlements, that's something else. If you're not paying, most businesses do, but if you're not, again, it's the enforcement aspect of it. What's important about this change is that I think it will all be dependent on how well funded and resourced the Fair Work Agency are, because we've seen it with the Information Commissioner's Office, the ICO, really good body, really good intentions in making sure that data protection, subject access requests are all dealt with properly and enforced. But again, the lack of resource and funding in that area has maybe seen it not be as maybe impactful as it would have liked to be. And again, I'm not sure if that would be the same for the Fair Work Agency, how well funded and resourced is going to be. The one thing I want to be very clear on this, though, is that the Fair Work Agency will be able to raise claims against employers in the employment tribunal, even when workers or employees don't want to do that. So if an employee went to the agency and said, oh, there are issues with this, could be, say, holiday pay, not happy about this, but I don't really want to say anything about it or do anything about it, there is nothing that would stop the Fair Work Agency taking it upon themselves to commence employment tribunal proceedings on that basis, and to get data, to get information, to have full disclosure as part of an employment tribunal claim. So again, that's quite a key area that could have a significant impact if it's well resourced and again it's implemented in that particular way. So that will be established in April next year, but again, it's not clear when the enforcement powers will come into force, but it's good for you to all have on your radar, because I think it makes us all sit up as businesses and as employers to go, is our house in order? If so, how confident are we? Do we have it all set out in a policy? Do we have it clear? Do our employees know where they can find all this information? Do our stakeholders know where all that sits? And again, from an employee perspective, how well communicated are they in terms of what their SSP is, how their holiday pay is calculated? And again, you just want to make sure that if you don't think your house is in order, now is a really good time to just spend some considered focus on where there might be gaps and get it all in place, so you feel comfortable and confident that when this all comes in, it's not something that you're concerned about if someone from the agency were to come knock on the door and go, can you show me this? How do you deal with this? How do you calculate that? Where is that kept? So again, it's a good opportunity to kind of do a self-audit of where you sit and how comfortable you are with that. So in terms of family-friendly rights, there's a lot going on here. I'm just going to go to my notes actually, because I've got some interesting aspects for this. So again, the additional protection against dismissal for returners from maternity leave. At the moment, there is what we call Regulation 10 rights for individuals who are on maternity leave. That's been around for quite some time. So that is when someone who is at risk of, has been confirmed as at risk of redundancy, either been selected for redundancy, someone who is on mat leave or maternity leave or is pregnant gets preference. It's a form of positive discrimination. It's the only one that's legislated in respect of any suitable alternative vacancies. Now, what that means is that if there is a suitable alternative vacancy and there were others at risk, the individual who is on maternity leave or is pregnant would get priority. It's the only time that happens. Now, what is now being proposed is additional protection against dismissal for those that are returning from maternity leave, in that for a period of 6 months, they cannot be dismissed when they return from maternity leave. I know that. So there's still finer detail to be understood around that, because my view is, I'm not saying this happens regularly, but say someone comes from mat leave and then they commit an act of gross misconduct within month 2, surely the government aren't saying that we can't do anything about that as a business. I don't think that's what they're saying, but again, the devil's in the detail, so it would be good to understand that. But usually, I would imagine it would probably apply maybe to performance or absence maybe, and you might have to just give a bit more leeway in that respect. Again, my view is redundancy. If someone's role no longer exists, is that something that's going to be kind of ring fenced? I'm not entirely clear on that, because if the role's not there and it's not existed, then they have the priority around suitable alternative vacancies. Is that sufficient? I don't know what the government's intentions are there. So again, just to flag that. In terms of the maternity, paternity, unpaid parental leave, they are all going to be day one rights. And what I mean by that is usually those rights are given once an employee has 26 weeks continuous service. That's not going to be required. The parental leave, paternity leave aspects are coming in, I think, next April. So that's something to be aware of, and make sure you have the correct policies updated to reflect that, and communicated so that everyone is aware of that. In terms of bereavement leave, that is looking to be extended. I think that's in 2027 to all workers. So it's a wider group of workers, but again, that who they will apply to will be specified in the future regulations. Again, we don't have detail around that, but again, the key area that I want to flag here is that there are changes that will happen. So just make sure you're keeping up to date with when this is likely to come into force, and that those within your business are fully aware of that. And again, miscarriage leave is another area that they're looking to implement as well. So as I've said there, the issue there is about making sure you have there is a greater need to really understand leave obligations at line manager level, because I have had cases where managers, for some reason or other, have thought, no, you're not entitled to this, no, you don't get this, which has been inaccurate or has just been plainly wrong. And I always find that employment tribunal claims come out of really sensitive situations and when there's been poor communication. So when someone is on maternity leave, not keeping in touch in the right way, not communicating in a sensitive fashion, or not understanding what the rights are or what the pay should be granted, it's not, usually we're all reasonable individuals. So if we mention to our manager or to our employer, I don't think I've been paid right, or I think I'm entitled to this, if the business go, you know what, you're right, we made a mistake there, we'll fix it, that is usually the end of it. But I've seen in a lot of tribunal claims recently, especially over the last 4 or 5 years, is that where businesses get defensive, they get it wrong, or they just don't understand, and then they don't communicate. They leave employees hanging for weeks, not knowing what the answer is. They don't try and find out who are the right people to kind of push these queries to make sure you're getting an answer there and then for the employee, because in certain circumstances, that's when emotions are heightened as well. You're out the business. So again, it's really important to understand you've got the right structure in place, and the maybe the HR team or the right specialists internally to understand what is the answer here, what are they entitled to. But your managers should really know that. So how are you upskilling managers to understand what that is, and if they don't know, who they're asking, because that's when I think businesses can drop the ball and can leave you open to discrimination claims. And the thing about discrimination claims is that any compensation there is technically uncapped, so it's not limited in any way. And if we have really treated someone badly, we've misinformed them, we've continued to deny them a right in any fashion, or pay or leave or anything like that, it can heighten things. The next one is around non-disclosure agreements. There's been a lot of this that has come out of, I suppose, the Me Too movement a number of years ago. But at the moment, non-disclosure agreements, they're not allowed to be used by businesses if what they are looking to do is to stop an employee making a protected disclosure. Now, protected disclosure is when you disclose something, you communicate something in a particular way that relates to a breach of maybe a legal obligation. It could be a health and safety issue. So one of the areas that is now being clarified is that sexual harassment should be considered a protected disclosure, i.e., if you are making disclosure around harassment, that is not something that you can carve out in particular agreements or as an NDA. So I think businesses will be concerned around this because normally if you're looking to settle a claim or enter into an agreement with an individual, you kind of want to know that that's the end of it. We're not going to hear anything more about it. But if it is around a protected disclosure and not something that has been raised or been dealt with, then I think that could be a factor that businesses would consider. So again, any amendments will be rendered void, or any clause in an agreement which precludes or prohibits a worker from making any allegation of or disclosure of information that relate to irrelevant harassment or discrimination, they're going to be void. So again, that's quite a key change and proposal, but it will not apply to accepted agreements. And again, that's something that we will need further clarity on what those accepted agreements are. Just seeing if I have any detail around what that is at the moment, and I don't think I do. But normally I would say that if you have dealt with a sexual harassment claim, whether it's an employment tribunal claim or a grievance, and you've dealt with it through the appropriate channels, through the grievance process, or you've settled it and you know what it is you're settling, you would assume that you'd still be entitled to settle on that basis, and for that not to go any further, because that is the whole purpose of perhaps paying a settlement amount in order to kind of not proceed to an employment tribunal. So again, we will give you more updates on that as and when we have it. And lastly, how am I doing for time? Yeah, I think I'm okay. Sorry. Just basically what's next. So the House of Lords consideration of the Commons reasons and amendments is scheduled for the 28th of October. Royal assent is expected this autumn. We're hearing early November, so we'll see. And when it does get royal assent, there will be certain things that will come into place. And again, consultations expected on trade union measures and dismissal and re-engagement. So again, we're still waiting to see how this is all going to end, because at the moment we don't have that. But we do have a steering group, which I'm part of internally here, that's always on it to understand where we are. So again, we've got stuff around the trade union measures, which I haven't really touched upon today, but it would be good at the end to understand if that is a concern or a consideration, because we can provide more detail around that. And again, the next steps around reasonable steps to prevent workplace sexual harassment are expected in 2026 or 2027, and that's the consultation around all of that as well. So again, as and when we have more detail. I feel like that has been quite a common phrase of mine. As and when we have more detail, I can let you know, but that is just the nature of it at the moment. Other than the stuff that's coming in April next year, we're kind of holding to the process. So I'm happy to take any questions. That's the end of my bit. I hope it wasn't too legal for you and I was able to digest it in a fashion that was clear for you all, and to understand, I suppose, how the practical implications or considerations might impact you as a business or as an organisation in any form. So, but that's me. I'm happy to take any questions.
Hi there. Yeah, Ingrid, I'll just open it up to the floor. There aren't any questions in the chat that I have seen. So we are stopping recording at this point. So you would be free to ask any questions